So why don't we go ahead and get started on some privacy topics. So we want to talk briefly today about some of the many trends continuing in privacy, AI, and cybersecurity enforcement. You'll hear a lot about privacy. That's where we're seeing a lot of enforcement right now that's been trending in a new direction, but we'll touch on some of these other areas as well. So just briefly about myself, my name is Paul Rothermel. I'm an attorney at Gardner Law. I'm at Gardner now about 5.5 years, along with Nate. And my focus in practice has been privacy, so HIPAA, GDPR, various state privacy laws that have become, a significant part of our practice and a part of compliance and privacy over time, and other privacy matters as well in cybersecurity, AI. And I'll let Josh introduce himself.
Well, hello, my name is Josh Arkulary. I am an associate attorney at Gardner Law, and I practice on the privacy team with Paul. My background is mostly in clinical research, where I spent the better part of a decade working with HIPAA and FDA regulations and global privacy regulations. Before joining Gardner a few months ago, I was on the R&D legal team of a biotech company, Regeneron Pharmaceuticals. And then before that, I worked for a few different hospital systems here in the US. I worked at the Minneapolis Heart Institute Foundation here in Minnesota. And then before that, or after that, I was at the Children's Hospital in Colorado.
Thanks, Josh. So we'll dive right in. So imagine, and keeping in mind, this is a topic today, a theme of 10 years. 10 years has gone by since Gardner Law was founded, but also let's time travel a little bit. The year is 2016. You just bought your brand new iPhone 7, and maybe you made your first order on the brand new mobile app for Starbucks to pick up. Seems like such a recent thing, but 10 years has gone by since all this has happened. So it is quite a bit of time in terms of technology and a very long time in terms of privacy law. Back in 2016, we were still talking a lot about HIPAA in terms of the primary enforcement area of this law, this area of law, and specifically we're concerned about the brand new two years out from the HITECH Act, which added specifically liability for business associates, not just the covered entity who could then go after the business associates separately, but directly those service providers could be under enforcement action from OCR and the federal government. State medical records laws still around, but they were a significant part of the privacy law landscape then. Children's Online Privacy and Protection Act, of course, the Section 5 of the FTC Act, and along with the Health Breach Notification Rule of 2009. So these various privacy enforcement mechanisms were available through these laws federally, and some state law, but not a significant part of privacy law other than some of these breach notification rules, and breach notification rules being, hey, something has happened and now we have to follow up with the subjects who are impacted. And the CCPA as well, which protects consumers essentially from unwanted texts or phone calls, those kinds of things. So now it's 2026, and Josh will fill us in on what's going on now.
Sure. So in 2026, as many of you probably know, privacy law is quite a bit more complex. In 2016, we were dealing with a handful of federal laws and a state law, governing medical records. But today we're dealing with this patchwork of state privacy laws. And California continues to lead the way with the California Consumer Protection Act and other laws and regulations in California. And in many ways, California created the model that many other states have created their comprehensive privacy programs from. And as you can see, now we're up to about 20 states with comprehensive state privacy programs that offer similar but not identical requirements. Mostly the similarities would include that the rights that they give consumers, such as the right to know the data that's collected about you from various websites, companies' websites and platforms, And then, of course, like opt-out requests. Now we see cookie banners and things like that you didn't see so much 10 years ago. And we also have 3 states with consumer health data laws that, this is at the state level, but it does go beyond HIPAA and applies to health data more broadly than just PHI. And then there's a handful of states that have AI governance laws, like Texas and Colorado have their own separate statutes governing artificial intelligence. And then we have like automated decision-making being regulated, sort of baked into the CCPA. And then, well, finally, we have old laws being used in new ways under the, specifically in California, under the California Invasion of Privacy Act. That's a law that was enacted way back in 1967 to govern wiretapping. So the recording of inbound and outbound calls. And obviously that applied specifically to the telephone then, but now plaintiffs' attorneys in the US and particularly in California are using this old statute and applying it to online tracking technologies and specifically pixels. And Paul's going to talk a little bit about this tension that we see in California right now, where this old statute is being applied in new ways, and then the divide in the courts, where some judges find that this statute does apply to online tracking technologies, others find that it does not. So that's high-level overview of 2026. So going back in time now to 2016 and to talk a little bit about the enforcement landscape. So cybersecurity failures and breaches were very active in 2016, particularly through the FTC. The FTC was using its authority under Section 5 of the FTC Act to govern and police unfair and deceptive trade practices. And in particular, companies are expected to implement what the FTC describes as reasonable security controls. So things like encryption and access management and having policies and procedures in place to respond to breaches. And increasingly, regulators were treating a breach not as an unavoidable event, but as perhaps an indicator that those reasonable security controls that the FTC requires were missing. And then inaccurate privacy policies. So something we might call truth in statements, where it's relevant in 2016 and relevant today, where companies should say what they do and do what they say in the privacy policies to avoid enforcement. And we'll talk about some specific cases involving inaccurate privacy policies as well. And then in 2016, HIPAA. HIPAA enforcement was also very active. It was a particularly big year for HIPAA enforcement. The OCR recorded record level settlements that year. They believe it was in excess of $20 million, $23.5 million, as well as multiple multi-million-dollar settlements. But what's perhaps more interesting and illuminating for this presentation is the shifting and the OCR's focus, not so much as the size of the settlements or the amount of data that was breached, but more so focusing on and targeting underlying systematic compliance program failures. So things like lost or stolen laptops or devices, not having proper encryption in place, and then covered entities like under the HITECH Act not properly overseeing and managing their business associates. So, so the message at that time for the industry was clear, where the OCR was shifting its focus, not so much from how big was the breach, but to whether or not that there was a strong compliance program in place. And then finally, as Paul mentioned, under the TCPA, this was actually a very risky area and privacy because of the damages model of the TCPA. Mostly this litigation and many companies across the industry found themselves in class action lawsuits, because of things like robocalls and robotext, things we're all very familiar with. And because of the damages model of $500 to $1,500 per call or per text, companies found themselves possibly incurring a significant exposure because of that damages model. So that's a high-level overview of a 2016 privacy enforcement landscape.
And all of those things continue today. So we're not seeing necessarily that these are going away, but now we've added a number of new areas of enforcement in 2026 that continue to challenge companies in terms of compliance. So I say know your data. So meaning more than ever, the government is interested and plaintiffs are interested in seeing companies that properly disclose or properly inform transparently about what their practices are with personal information. But additionally, how does that flow? Who accesses that information? Is it shared with third parties? And without knowing, directly what's occurring within your systems, within your data flows as a company, you're liable. You're likely to find yourself subject to liability or in violation of one of these many privacy laws. So you must know what you have, where it is, who has access to it in order to comply. And so that bleeds directly into some of the enforcement areas that we see. So business models that various companies use, whether that's so-called data brokers or this sort of more common sort of model of ad tech where Google or Meta or these other significant technology companies, they collect and use data in a variety of ways, but the main goal is to produce better marketing. And so there has been a focus in a lot of the current laws and enforcement activity on specific business models, not simply on the activity, but the model itself. And so we even see some enforcement and activity around the concept of a data broker. And so that's an organization that essentially sucks up a lot of data from individuals, but through kind of secondary sources. So they're not necessarily directly collecting it, but they have cookies or other trackers that they might use to collect data, or perhaps buy that data from other organizations. And so those models themselves can be suspect. And so it's important, if you're engaging with those organizations, to understand what kind of business model are you engaging in? What is the data flow? Again, know your data. We also see a lot more focus, and I'll mention a case later, where secondary use and sharing of data has become a significant enforcement emphasis. So rather than simply, we had a breach, an unauthorized hacker got into the system and is misusing our data, demanding ransoms, things like that. It's also, there's a focus on internal or even potentially company authorized use of data that runs afoul of perhaps the original intent of collection, the disclosures provided, the consent that should have perhaps been obtained. And so there's more of an emphasis on use of data within the company or through sharing. And then to cap all of this, a major point of emphasis is online tracking technology. So that's cookies, pixels, various other ways that data is collected through websites or apps, and then used in different ways. And a really key point is online tracking technology is a broad term, and I'll briefly show a slide, but I don't have time to go all the way through it. But that covers a number of different types of tools or code or scripts that can be on a website or in an app that significantly affect data flow and transfer and sharing. So I won't dig into all of these, but just understand that when I mention that, it's referring to a kind of collection of technologies. So we'll talk now briefly about some privacy claims, some enforcement activity that's taken place over the past few years. And we'll get into a couple of cases. Our focus will be mostly on health information and technology related to that, with the understanding that this audience will probably be more interested in that, though there is a lot more enforcement out there. And we'll mention a couple of cases that are maybe a little bit less health related, but have some key insights that we think are relevant to this group. So I'll pass it over to Josh to highlight one of the cases that was really a main kind of starting point for some of the enforcement we're seeing today.
Thanks, Paul. So GoodRx is a company founded in 2011. And for those of you who don't know, they offer prescription medications at a discount. And starting in about 2017, for about a 4-year period, GoodRx displayed on its website to users via different privacy notices and its privacy policy that their customers' personal information and personal health information would never be shared with third parties for advertising purposes. And they expressly said that it would never be shared with third parties for advertising purposes, and that to the extent it was shared with third parties, it would be for limited purposes otherwise. And the FTC alleged also in its complaint against GoodRx that GoodRx also displayed a HIPAA seal on its website, even though it's not a covered entity and not directly subject to HIPAA. So the reason why we're talking about this case is, of course, GoodRx did indeed share users' personal health information and with third parties such as Google and Facebook and Twilio and others for advertising purposes. And in the case of Facebook, actually shared users' personal information such as the health conditions they have, types of medications they were taking. So then a company like Facebook could generate targeted ads toward their types of medication they're on or health conditions they have. So using very sensitive information in a fairly egregious way. And so with the combination of the HIPAA seal, the FTC alleged this was further deceptive acts towards the consumers. And they also noted in their complaint and found it noteworthy that when GoodRx engaged these companies like Facebook and Twilio and Google, they accepted their standard terms of service, which meant that these companies like Google and Facebook were able to use these users' personal information for their own purposes. In other words, allowing these companies to profit from their customers' data. And so we just go on to the next slide and talk a little bit about the enforcement theories. So, like I mentioned earlier, the FTC's one of the main enforcement theories is unfair and deceptive trade practices. And there were multiple alleged violations of the FTC Act where GoodRx said they're going to do one thing in their privacy policy, and then in turn did another with persons' data. So, and then in addition to that, for the first time, the FTC used its authority under the health breach notification rule and found that GoodRx's acts of disclosing users' personal information to third parties without appropriate disclosure amounted to a breach of their health information. So what's the takeaway from all of this? So in addition to a $1.5 civil dollar, I think it was 1.5 civil monetary penalty and a lifetime or indefinite ban on GoodRx being able to share users' personal information to third parties for advertising purposes and loss of trust with the consumers, there are a few key takeaways for the healthcare and med tech industry. And the first would be that companies, of course, need to be truthful and accurate and with the information they put on their privacy policies. But even more important than that, and where the rubber really meets the road, I think, is ensuring that how data is actually used, shared, and so forth aligns with those privacy policies. Because going back to the late 1990s and early 2000s, the FTC and today has been using its enforcement authority against companies going back in the early 2000s against companies like Microsoft to today with companies like GoodRx and BetterHelp, finding that those privacy policies were inaccurate. But the last, I think, takeaway that we'd like to mention for this case is when Paul and I review our clients' contracts, when they are engaging with vendors or various partners or other companies, that we very often see that these other parties want to be able to use the data they're going to receive in performance of those services for their own purposes. We live in an age where data can be monetized, and especially with artificial intelligence, companies have an interest in being able to utilize the data that they might receive for their own purposes to perhaps, for example, train AI models. So, we would recommend that, companies pay close attention to those agreements when you're engaging with other companies to see what rights you might be affording those companies with respect to your data that you're sharing.
Yeah, thanks, Josh. And I would add to, some of the engagements we see are in these direct consumer spaces where there's, an interest in who do we target these direct to consumer ads online to? Is it through ads, kind of stereotypically through, websites that people are visiting? Well, you need to engage an ad tech partner to do that. Maybe sometimes data brokers become involved, and those agreements are often very complicated, and they involve some potential sales of data or personal data or sharing of data in ways that might, raise the eyebrow of the FTC or other regulators. So we do see that pretty regularly. Just want to highlight a couple of other FTC cases. So this is not a standalone case, and there's many more like this, but there are a few others that involve health information specifically for companies that were not covered entities. So HIPAA did not apply to them, but they did have health information, through their website. And so BetterHelp and Monument are other examples where the FTC found that online activities were being recorded through cookies or other online tracking technologies, and then pieces of that information that revealed health data about individuals were then shared with ad tech or other third parties for advertising. Again, this is a really key point of emphasis for enforcement right now. So I'll just briefly mention this one because it's really the first major enforcement that we've seen under the CCPA, so the California Consumer Privacy Act. And so that was passed in 2018, and then soon after we started to see the California Attorney General pinpointing different areas of enforcement focus. So this very first one was about essentially that Sephora didn't do a good enough job of disclosing their sale of personal information and their sharing of that information for advertising purposes. And this also highlighted that in California, not only do consumers have the right to opt out of this kind of sale and sharing for advertising purposes, but they also need to be able to do so through what's called a global privacy control signal. So that would be a signal that their browser is configured to send, and then that is transmitted to the server that hosts the website, and they should then know from that signal to turn off tracking of this type. So that was part of the enforcement activity here. So we've known for a few years now that kind of signal needs to be acknowledged and recognized by websites in order to avoid potential liability under this law. And one of the results here was that we saw that penalties would be in the same kind of vein that the FTC has been seeking in these same kind of actions. Another similar kind of case here, but involving health information. So healthline.com is a website that essentially provides information about various diagnoses or conditions. So if a consumer has, some sort of question about their health, they might go and find a website like this, search for articles about that condition, read them, and maybe read a few of them. Well, the thing that is happening in the background in a lot of these websites is that this information about consumers is monetized or used for advertising. And so it happened that Healthline primarily was using information like this as its main source of its income. And so the allegation here was that information that was being shared with third parties, monetized, and used for targeted advertising purposes was done so unlawfully. And so the problem was, even though Healthline had a banner that ostensibly opted out users from this kind of sharing, the banner was not functioning properly. At least that's the allegation. And so information, including things like article titles that users were reading or viewing, were shared with ad tech partners. And so, similar to the other cases we've talked about, this meant that third parties that had no connection to that individual were kind of indirectly receiving this information and could use it for various purposes. So you see here some of the same themes. Contracts with ad tech partners didn't have the mandatory terms that are required by the California Consumer Privacy Act for sale and sharing of personal information. They lacked controls around actual sharing, so consent banners weren't properly configured. And that ultimately resulted in a significant settlement and then some injunction of further sharing without user consent. And I'll pause here to give Josh the chance to talk about another very recent case that highlights another aspect of this law.
In February of 2026, Disney and the California Attorney General reached a settlement for Disney's alleged failures to honor consumers' opt-out requests using the Disney platform. So what that meant was the Attorney General office alleged that when users would opt out, for example, if you're on your laptop or you're on your iPad and you're watching Disney Plus and you opt out to the selling and sharing of your data, that opt-out was only working with respect to your iPad and on Disney Plus. So then if later you're watching ESPN Plus on your phone, or I'm sorry, on your phone, if you're connected TV, that opt-out would no longer apply. You'd have to re-opt out. So what they found was users might have to opt out up to 10 times in order to fully opt out from the Disney platform across all of their devices. So the Attorney General noted in a press release that customers or users shouldn't have to opt out to infinity and beyond, right? So that's like the key takeaway here is that for medical device companies where you might have a website for your company and then another website for your product and then an app that attaches to a device, to ensure that opt-out requests are functioning across the whole platform and not just one device or one website. So that's a key takeaway for compliance with the CCPA and many other comprehensive state privacy laws that have opt-out requirements. And the one more thing just to note about that really quick would be, Disney's defense in this was, that it would be really difficult to identify an individual across their various devices and platforms. But the Attorney General office did not find that very persuasive because they remarked that if you're able to identify a consumer for advertising across various devices and across different websites, then you're certainly able to identify them to honor their opt-out and data choices. So.
Yeah, thanks, Josh. And I'd add to that topic generally that opt-outs can be a tricky thing to administer. So there's upfront, on the website, you might have a cookie banner that says, reject all, so that they can opt out of kind of sale or sharing of their personal information at that point. But maybe down the road, they might opt out. You might have data that's already in your systems. There's other activities down the road that might apply to that same data set. So if they've opted out, that applies to the consumer data you've already collected that might sit in your customer record management system or other places in the business. And so that's critical to have some way, as Josh just noted, of applying those opt-outs across the board and not have it become sort of you have to opt out again and again for different segments of our record systems. And actually, before I dive into this next topic, I just want to briefly mention there was a case in the past week, so it's not in our slides, but General Motors had a recent $12.5 million, or I think about $12.75 million settlement for privacy violations with California Attorney General and there are other parts of, I think, Los Angeles County, some other divisions involved as well, but the key point there was that they were selling information allegedly from consumers who were using the OnStar system in their vehicles. And so their promise up front had been, we will only use this information to provide the services. If you need our services through the OnStar system, we'll use that data. But it was found, or the Attorney General found that over time, they then kept that data for a very long period of time, for over 5 years after it was needed, and then began to sell that data to companies like LexisNexis and Verisk and these other sort of companies that could package that into a product to sell to car insurance providers. So there was a clear kind of challenge in terms of data limitations and use and minimum necessary use, which to date hasn't really been a primary focus of enforcement, but this concept of reuse of data later is a typical requirement in law. We just haven't seen enforcement like this until very recently. So we'll keep an eye on some of those developments, but that's a key case that we felt was important to mention. And then lastly, I'll just briefly mention this because it is a big topic right now. We have many clients who've talked about this with us, but California Invasion of Privacy Act claims and other kind of related claims are coming from plaintiffs, and the focus, similar to some other plaintiff litigation, is on the ability for the plaintiff to recover damages if these rights are violated. And so they're targeting, as Josh mentioned earlier, using this law from 1967 that used or targeted specifically phone calls and the wiretapping problems that they were trying to address in that law originally, but this general use of that law to apply to online tracking technologies that are common today. What's especially tricky about this is that if you comply with, say, the California Consumer Privacy Act or other state privacy laws, that does not necessarily mean that you've met the standards that plaintiffs are demanding under this statute. And you'll see the kind of the mitigation options below. A, you have to know your data, but B, the CIPA is being applied in a way that requires explicit consent before any tracking occurs, before any data collection occurs, which is a kind of higher standard than the implied consent with an opt-out right that the CCPA administers and most state privacy laws do. So that's a challenge. We're seeing courts divided on the applicability of this rule, and it continues to be a kind of a challenge. We will see where it goes over time. So what comes next? I just want to briefly mention, as we're running out of time here, we're seeing more and more regulation around artificial intelligence. We're seeing that in Colorado, although they just repealed and replaced the bill that had been kind of controversial on AI governance there in the past week. So we'll see kind of how that fleshes out and impacts other states who are thinking about the same kind of AI regulation. Many privacy laws include automated decision-making technology rules. California kind of leading the way again on that, but we're seeing that elsewhere. There's this concept of privacy risk assessment. And so many of you probably know what a quality system kind of risk assessment looks like. This is a little bit like that, but in a privacy directed way. So looking at what are the risks to consumers, what kind of mitigation controls are in place. That's becoming required by many state privacy laws, including California, which has finally released their rulemaking on that recently and finalized it. And then shifting cybersecurity requirements. So we are seeing states implement more strict cyber requirements for personal information. California has added some significant auditing requirements for cybersecurity that will kind of roll out in the next year in different kind of levels. And then we're also waiting to hear about HIPAA and how the security rule, notice of proposed rulemaking that we just saw not too long ago. It's been sort of silent, so we'll see if that comes out in part or in full as a final rule in the near future. So I think that wraps up our time, but happy to discuss later if anyone has any questions.
Can you, for just a moment, Paul, also, you and I put an alert out, and just bringing this up a little bit. There's this plaintiff's lawyer in California that's suing a lot of companies, especially in medtech. That's been kind of a popular target. I just thought it's not as leading as some of these cases, obviously, that you presented here, but maybe for the audience, just for a moment, because I know this is more of a nuisance type of plaintiff that will just cost you some money if you don't kind of yield to his demands. Or could you just talk for a moment about that? Because I know we've had several clients hit by it, so we actually put an alert out on this situation.
Yeah, and I think just to kind of go back briefly to this topic, we are seeing this happen to our clients. They're receiving demands based on the CIPA and other kind of related laws. This is real. It is happening. So if you have, a website and there's any kind of marketing tools on there, you may be subject to this kind of, you could call it nuisance litigation, but it does have enough merit that courts are listening to it. So it's not just a summary judgment issue, but it's getting beyond that into discovery in many cases, depending on the facts. And each fact pattern is different. Each court views these fact patterns a little differently. And we don't currently have great kind of long-term ideas about what the courts will ultimately find. So we're still kind of seeing this play out. But again, this is a hot topic.
Just going to add that this individual has probably made enough money to buy a small island in the Caribbean with all of the settlements that he's garnered from the CIPA, right? So it's kind of, is that the law that it's the 1967? It's like some ancient law that he is citing, but then he's extracting settlements from companies. So it's kind of crazy.
And I'd add, it's not just one plaintiff. It's a number of plaintiffs that are bringing these actions. So someone mentioned kind of like copyright trolls a little bit. And I think it's challenging because the law just isn't that clear. And so although it feels really out there to us, as companies trying to do the right thing, it can be, I think from the plaintiff's perspective, they're saying, look, they're not doing it quite right. We're going to take advantage of that. So for now, I'd exercise caution and try to address this before you get a demand letter, in your mailbox.
Make sure you have a privacy policy on your website is the punchline. Like if you don't have one, you might get a demand letter. And, to present the plaintiff side of this, it's like people are collecting your data and who knows what they're doing with it, and they're making money off of it. So this individual is, helping police, if you will, the system. So that's kind of a part of our culture here in the US. You've got plaintiffs' lawyers doing lots of things. There are benefits from them, but it ultimately does drive up a lot of costs for industry, obviously.
Yeah, thanks, Mark. Thanks, everyone.